Welcome back to The Verdict. Mick Cornett with Kent Myers, and we're glad you're with us. We're here each week meeting interesting people and talking about topical issues. And today we're kind of going to get back to our roots and talk about legal issues.
Yeah, so we're going to have a fascinating show today with Professor Joe Tye at the University of Oklahoma College of Law. We're going to be taking an insider view into the U.S. Supreme Court. Professor Tye has had and does have prior experience with the U.S. Supreme Court as a clerk for two different justices, and maintains contact with the court. And he's going to discuss some of the new decisions we've had in this last term. We're going to talk about the new Chief Justice. Well, he's now 2 terms into it, Chief Justice Roberts. We're going to talk about what's in store for the court in the future. I think you'll find it very, very interesting.
A lot of controversy about the Supreme Court. We'll delve into that today on The Verdict. We'll be right back.
What if America had its own clean energy? Abundant and available for the next century or more, and possibly indefinitely. A true 21st century energy source would cut carbon emissions in half and do every living thing a world of good. That clean American energy exists. It's natural gas, and Chesapeake is its #1 explorer. For producing clean electricity and fueling our cars without imported oil, natural gas saves money and the environment. Proving the answer to this country's energy needs is right under our feet, and we're not running out. Clean, abundant, affordable, American natural gas. Doing a world of good for our communities, our economy, and our irreplaceable planet Earth.
Welcome back to The Verdict. Mick Cornett and Kent Myers, and Kent's going to introduce today's guest.
Very pleased today to have Professor Joseph Tye, Joe Tye, from the University of Oklahoma College of Law, who's a presidential professor of law at the University of Oklahoma. He did his undergraduate and his law work at Harvard University. He has served as in private practice. He has served the University of Oklahoma as a professor since 2003. As a matter of fact, in 2005, he was selected as the outstanding professor at the entire University of Oklahoma campuses. He served as law clerk to both Justice John Stevens and Byron White while on the U.S. Supreme Court. And he's here today to talk to us about kind of an insider's view of the court both then and now. Professor Tye, welcome.
Well, it's a pleasure to be here. Thanks for having me.
We're glad to have you.
A very diverse background. What drew you to the University of Oklahoma's law school? Why are you here?
Well, first, just to step back a moment, I actually grew up in Tulsa, but I attended college and law school at Harvard, and there I met a wonderful, beautiful woman who, in an uncharacteristic moment of bad judgment, agreed to marry me. She's from Boston, but we both decided that Oklahoma would be a better place to start a family and raise kids, and that's what we wanted to do, and so that's where we ended up. And once I was here, Oklahoma was just an ideal fit for me. It's the flagship university of the state. It educates and trains the best lawyers and leaders of the state in this country. You know, Kent is a living example of that across the table from me. It has a great dean. You know, always good to plug your boss on TV whenever you can. And so I feel extremely fortunate to be at OU.
I noticed that you were a law clerk to Justice John Paul Stevens
Yes.
For 1 term. And I think you had some additional jobs besides that in relation to the court. But tell us about Justice Stevens. How old is he? Do you keep in touch with him? How long do you expect him to continue to serve on the court?
Well, he is 88. He was born in 1920, though you would not know it from seeing him. He's as sprightly and as energetic and as funny as anyone you could imagine, including Jay Leno, for example. Although he's also one of the sharpest and brightest and most serious people that I know. He still swims in the ocean whenever he can. He plays tennis and golf every week, and so he's still very healthy and very active. I imagine he would stay on the court as long as his health permits him, at least into the next presidency. I do try to stay in touch with him on a pretty regular basis. For example, every December 12th, which is the anniversary of Bush v. Gore, the major decision when I clerked on the court, we the co-clerks for Justice Stevens, we send him a gift because he dissented in that case. He was profoundly sad by the outcome. He thought that the state courts should have been left alone in that litigation, and so we send him a gift every December 12th as a silver lining on the cloud. And he always writes us back a very gracious note, not only thanking us for the gift, but also thanking us for our work on the court and on that case.
Let me follow up with that just a little bit on something that we hadn't talked about.
Sure.
You were a clerk for one term.
That's right.
At the Supreme Court. But how does one get employed as a clerk in the United States Supreme Court? And am I too old to apply?
You're certainly not too old to apply, nor are you too young to apply. A lot of luck and good fortune. Obviously, your academic credentials has to be there. You have to have the recommendations from your law professors and from your appellate court judge that preceded your Supreme Court clerkship. Beyond that, the justices are looking for law clerks who they can work with, who they would enjoy spending a year with. There are too many candidates who are qualified for the position. Hundreds apply every year. I was abashed when I was inside the court and reviewing the applications, realizing that, boy, I was really lucky and I really should not have been hired. But thank the lucky stars that it's too late to change that decision. But once you make the initial cut, it's basically personality, who the justice thinks that they would enjoy working with for a year.
What do the clerks do?
They basically do everything that the justices ask them to do. On a basic level, they help prepare the justices for the oral arguments that they hear in the cases that they're set to decide. They help them draft the judicial opinions that decide the decisions. At the Supreme Court, they also help oversee the executions. The Supreme Court is the court of last resort for people on death row, and so before they go up for execution, the Supreme Court ultimately is the last judicial stop along the way. And so they help them with executions as well as other emergency matters. And some justices employ their law clerks for speech writing as well, although Justice Stevens was very conscious of the amount of time and responsibility that we had just doing the work of the court with him, and so he never really imposed upon us for that.
How do you assess the court now that John Roberts is the Supreme Court Justice?
Well, I give the court mixed reviews now. I think on an internal level, it's a much more collegial, much more energetic, much friendlier place to work. I think Roberts and Alito, by all reports, internal and external, have been great additions to the court. Roberts has also relaxed some of the protocols within the court that make it easier for the justices to work with each other. For example, under Chief Justice Rehnquist, previously at conference, they were pretty formal affairs where the justices would go down the line by order of seniority and vote on the cases that they've heard and just give their reasons very quickly as to why they're voting that way. Under Roberts, from what I've heard, there's more conversation, there's more latitude to discuss cases before actually voting on the cases. And so I think every justice on the court is pleased with some of the changes that have occurred under Roberts. But in terms of decisions, it's a very mixed court. The Rehnquist court was known as a heavily divided ideological court, and the Roberts court, at least in its first term, was even more divided than the Rehnquist court. And the interesting surprise is that the division is not between the liberals and the conservatives, but the sharpest divisions have come between the conservatives themselves. Mm-hmm. As it turns out, there are now two types of conservatives on the Supreme Court. There's the type that would like to overrule cases that do not match their view of the Constitution, like Roe v. Wade. And those justices include Scalia, appointed by Reagan, and Thomas, appointed by George Bush, the first George Bush. And then there are those who would prefer not to overrule cases outright, but actually to just undercut or to distinguish cases one case at a time. And that would be Roberts and Alito. And so you have two wings of the conservative court deciding between and debating between overruling or just moving one case at a time.
Can and do justices discuss cases outside of normal applications, and can they get together in groups behind closed doors and discuss cases?
Well, they do, and they actually did, I think, quite a lot more before I clerked, and I think before Roberts took over. During the Rehnquist court years, at least when I clerked, from what I heard and from what I observed, a lot of the communication was formal, and it occurred, interestingly, often during oral argument. That was often the first period of time when the justices collectively would get together and hear what they each have to think about a case. And so oftentimes at oral argument, when they asked a question through counsel, it was literally through counsel to hear what the other justices would have to say in response, or to lobby the other justices. They sometimes circulated formal memos, but I did not see the kind of informal personal interaction that I had heard about during the Warren court years or the Berger court years.
When you're dealing with a case,
Yes.
Do the justices tell you how, when they call you in to talk to you about it, tell you how they expect it to come out, now go find it and justify it, or do they say, I don't know how this is going to come out, tell me what you think? How does it work?
Well, you know, I can't speak for the other chambers, but in the Stevens chambers, I was pleasantly surprised that Justice Stevens never once tried to predispose us to a particular outcome in any particular case. And part of the fun of working with him is that we would both work in parallel. We'd both read the briefs and prepare for the oral arguments, and then he'd just kind of sit us down and he'd ask us first, well, Joe, what do you think of this case? And I think he did that so that we wouldn't just listen to his views and parrot him, but we'd give him our opinion, and then he'd always say, well, but what do you think of this? And then we would respond to what his thoughts were on a case. And even if we could not agree, we'd always try to work toward a principled, reasoned basis for disagreement. And he was always careful to say that, my door's always open. There's always a petition for rehearing among law clerks. And often he would complain that, I'm the only dissenter in chambers, but unfortunately my view counts.
You mentioned the word lobbying between one justice and another.
Yes.
I guess I hadn't really known that takes place, but is that fairly common?
Well, it was notorious during Chief Justice Berger's term. If you read The Brethren, the infamous book by Bob Woodward, you would hear stories about Berger going into other justices' chambers to lobby them personally, and that was received with some distaste within the court. And I think Rehnquist was a great administrator who was consciously aware of his power as Chief Justice, and he kind of backed away and made dialogue within the court more formal. And I think the justices at the time appreciated that additional breathing space. It was, in my experience, quite rare for a justice to go and personally lobby another justice on a case. And part of the thinking behind that is that, well, you know what, each of us, we're competent, we've been chosen, and we've been confirmed, and we respect the work that each of us does in chambers, and it's unlikely that we would be able to prevail upon our colleague if they've done the same homework that we've done.
Joe Tye is a professor at the University of Oklahoma's Law School. He has experience as a clerk on the U.S. Supreme Court. We have a lot of individual cases we want to discuss in our next segment. You're watching The Verdict.
Home values are down in some states, but not in Oklahoma. Oklahoma's home values have increased 4.2% during the past 12 months. Unlike some states where home values have decreased as much as 20%. Good thing you're in Oklahoma. There may be real estate problems in some states, but there has never been a better time than now to buy or sell a home in Oklahoma. One of the most affordable states in the country, Oklahomans are buying and selling homes every day, and an Oklahoma realtor can show you how. Good thing you're in Oklahoma.
That land next door was a mess. Take more than a lawnmower to revive that land. I heard the oil and natural gas people was cleaning up old oil sites, and it wouldn't cost us a plug nickel. Oh yes, sir, it was quite a revival. The whole church showed up, want to make a playground for the kids. It sure is a blessing.
Wilsey, Meyer, Eatman, Tate. We're accountants. We do taxes, business valuations, estate planning, and consulting. And we're right here in Oklahoma, working with the owners of small and medium-sized businesses. Steve Wilsey and Stuart Meyer have the resources and the experience. Wilsey, Meyer, Eatman, Tate in Oklahoma City and Tulsa.
We're back on The Verdict. Joe Tye is our guest. We're discussing the Supreme Court. He was a clerk under two different justices. And Kent, I know we want to discuss some individual cases that have been handed down recently.
Yes, this term just completed. Had several very interesting cases I'd just like your view about and to tell our viewers about. Let's talk first about the Washington, D.C. handgun decision.
Well, that was the last decision that the court decided, and it certainly ended the term with a bang, if you excuse the pun. The Supreme Court hadn't discussed the meaning of the Second Amendment right to bear arms for over 7 decades. In the 1930s, it had suggested, although not squarely held, that perhaps that right to bear arms was related with the ability of the state to maintain well-regulated militias. But in a 5-4 deeply divided decision this past June, the conservative wing of the court held that the Second Amendment, at its core, protects an individual right to bear arms that's wholly unconnected with the ability of states to have well-regulated militias. And the court held that regulations that interfere with this core right to use firearms for traditionally lawful purposes, such as self-defense within the home, violates the Second Amendment. And as a result, the court struck down D.C.'s ban on handguns, which was a categorical ban on handguns within the home.
What about the capital punishment for child rapist decision?
Well, that was an interesting decision. It was a 5-4 decision again, but this time the moderate to conservative wing prevailed. And in the 5-4 decision, what the court held was not only was capital punishment for child rapists unconstitutional in violation of the 8th Amendment prohibition against cruel and unusual punishment, but also any other non-homicide crime where death was not intended to result and did not actually result, at least for person-on-person crimes. And that decision was interesting on several fronts. One front was because victims of, groups that advocate and treat victims of child rape and child sexual abuse actually lobbied in favor of that outcome. And I have to confess personal bias because I represented those groups, sexual assault trauma centers and other social workers that deal with victims of sexual assault. And what they argued before the court was that, well, you know, capital punishment in the child rape context actually counterintuitively hurts children more than it helps them.
And explain that.
Well, what these social groups, from their experience and their studies, strongly believe is that if you impose capital punishment for child rape, it would, one, exacerbate the problems of underreporting. Child sexual abuse is a severely, extremely underreported crime, and if the death penalty is the ultimate penalty, then it would make people even more reluctant, victims even more reluctant to come forward when daddy or stepdaddy or the uncle is the perpetrator, and would also prolong and deepen the trauma that these groups know children experience when they're in the criminal justice system, which they would have to be in a capital case.
That was 5-4.
Yes.
And who wrote the opinion on that one?
Justice Anthony Kennedy, and the case was Kennedy versus Louisiana, if that's not confusing enough.
The different Kennedy.
Yes. Yes, a different Kennedy.
Now, the one that seemed to get as much publicity as any of these cases is the decision dealing with the detainees at Guantanamo. Can you tell us what that decision is and what impact, if any, it has?
Sure. Well, that was another deeply split 5-4 decision, and in that case, again, the moderate to liberal wing of the court prevailed over the conservative wing. And the court held that the constitutional protection of habeas corpus extended to Guantanamo Bay, naval base Cuba. Now, let me try to unpack that for those who are non-lawyers and non-Latin scholars. Habeas corpus is an ancient right that was protected way back when, even during in the Magna Carta, that assures that a prisoner has the ability to go to court and force the custodian to justify the legality of their imprisonment. And what the court held was that Guantanamo Bay is a place that the Constitution extends to, at least with respect to habeas corpus. And so therefore, our detainees there at Gitmo have the ability to go into federal court stateside and make the administration explain and justify their detention under U.S. law.
That was a huge blow to the Bush administration.
Oh, undoubtedly, and this was the third blow to the Bush administration on its Gitmo policies. The court had previously held that the detainees had a statutory right to go to federal court. Congress repealed that statute. The court then held that the military commissions that President Bush had set up to try these detainees violated U.S. law. Congress then, with the Bush administration, rewrote those laws so that the military commissions would comply with federal law. And now in this third case, the Bush administration put forward its core theory about Guantanamo Bay, which is that it is a legal black hole. After all, the reason why they brought all these detainees there was that they felt that they could bring them there and keep them there safely outside of the reach, not only of the allies of al-Qaeda, but also out of the reach of U.S. courts. But the court held in no uncertain terms that Guantanamo Bay is not a legal black hole, and moreover, that the courts have a role in the war on terror. And that's a big blow to the Bush administration's policy of proceeding unilaterally in the war on terror. So for better or for worse, this decision brings the security problems that are out in Afghanistan and Iraq, perhaps to Main Street USA, because the Bush administration will now have to justify the detention of these detainees in federal court, and if they cannot, then they're going to have to work with Congress or other countries to make sure that there's a safe place to put these detainees.
All three of these cases were high profile. All three were 5-4 decisions.
Yes.
Now, Sandra Day O'Connor, a Reagan appointee, is often considered the swing vote. Was she a swing vote in all three of these decisions?
Well, actually, she had retired by the time these decisions came out, and so there was a new swing voter that emerged on the court, and he's Justice Anthony Kennedy, and quite ironically, he's loved and hated by both the left and the right because he swings both ways. But the interesting thing about the way he swings, and it's a measure of where the court is now, is that he's more reliably conservative than Justice Sandra Day O'Connor. They were both Reagan appointees, and so the new middle on the Roberts court is to the right of the middle during the Rehnquist years. But that said, he tends to swing to the left on death penalty cases and on war and terror cases that implicate the power of the judiciary. And so you have an interesting dynamic on the court where perhaps on traditional law and order issues, it's a very conservative court, much more so than during the Rehnquist years. But on social issues and on separation of powers issues, you have a court that is proving to be reliably moderate to liberal.
Now, would a scholar that studies the work of the Supreme Court be able to reliably predict how individual justices will vote on particular cases?
Well, I wouldn't put my money on it, but yeah, if you're going to ask me for a free opinion, I'd certainly be happy to give you one. I think Justice Kennedy has shown a willingness on social issues such as gay rights and on issues that implicate the power of the judiciary to be more moderate to liberal. But on core conservative issues, law and order issues, what powers the police have to engage in searches and seizures, the power of states vis-a-vis the federal government, I think he's reliably conservative, and he's proven reliably conservative lately on abortion cases as well.
How do you assess the U.S. Supreme Court's jurisprudence over the next 5 years?
Well, that is the big question, and that's the elephant in the room for this upcoming election. I think it will critically depend on who gets elected. If you do the inventory list of justices that are likely to retire in the next 5 years or so, they're the justices on the moderate to liberal wing of the court. My own boss, Justice John Paul Stevens, bless him, at 88, healthier than whippersnappers like me, but at the same time, he's 88. He'll likely retire during the next administration. Justice Souter, a Bush 1 appointee, is also frequently mentioned as a possible retiree, as well as Justice Ginsburg, a Clinton appointee. And so essentially the next three retirements are likely to be moderate to liberal justices. And so if a President Obama gets to pick their successors, all that he can manage to do is keep the same holding pattern on the current fairly conservative court. If John McCain becomes president, however, he has a once-in-a-lifetime opportunity to reinforce and solidify the conservative wing of the court.
I think that's about it.
Okay, we're just about out of time.
Oh,
we're not out of questions.
Just in the last few seconds we have left, is there a trend among presidents who have a legal background, who have a law degree? Do they tend to take more of their own experiences in hand when they select their justices?
I think so, and President Clinton proved that he was very interested in the selection process. On the other hand, some presidents have been more offhand about it, just President Reagan, for example, and President Bush 1. I think he delegated a lot of the selection process to his subordinates.
I see. Joe Tye has been our guest. Joe, we're going to have you back on. There's not enough time today to get to all the interesting components of this interview.
Well, I'd love to come back. Thanks for having me.
All right.
Thank you.
Kent and I'll have a final word right after this.
The good life comes naturally to Tulsa, where nature's beauty is matched with an eye for aesthetics. A legacy of neighborhoods graced with lawns and landscaping and handsome homes. A place that seems to have patented an ideal lifestyle. Bank First is loyal to the quality of life Tulsa assures its citizens, to the priority placed on education, culture, and growth. Loyal to builders who transform raw land into residential charm. Developers who see opportunity and add vitality to Tulsa's economy. Bank First serves both enterprise and private lives that need a loyal partner. It's how we help nurture this city's very good life. Bank First. Loyal to Oklahoma. Loyal to you.
The Journal-Record is pleased to be a sponsor of the verdict. The Journal-Record, since 1903, the best source of Oklahoma business news and legal information.
Still so surprising to me in general that there can be so many conflicting opinions about addressing constitutionality.
Yes.
And have so many 5-4 decisions.
Well, and when you think about it isn't necessarily so much the outcome sometimes, it's how you get there. What methodology do you use to get there? Are you going to look just at what the mores of society today tell us, or are you going to try to be a strict constructionist and look at it saying, what were the framers of the Constitution thinking when they said that? That's what we need to follow, not how society has changed. And if you, that's basically behind most of the divisions on the Supreme Court nowadays.
I see.
Is what's your starting point? That kind of depends on that, determines how you come out.
That makes sense.
Joe Tye is just an outstanding guest, of course, outstanding professor at the University of Oklahoma, and we'll have him back. And speaking of educators, this next week we're going to meet the new superintendent of Oklahoma City Public Schools.
That's right. Carl Springer has hit the ground running, and we'll take a look at what he has ahead for the Oklahoma City Public School system. Well, that's going to do it. Let me first, though, before we go, give you our email address and our website information. It's theverdict.tv. You can go here, drop Ken or I an email, tell us about a guest that you would like to see on an upcoming edition of The Verdict. And we'd love to hear your feedback, because hearing the types of shows that you'd like to see helps guide us and helps us invite interesting people for us to view down the line, and just like Joe Tye today, speaking about the constitutionality and giving his views on the court. Yeah,
and we're going to have him back to talk about a prior term of the U.S. Supreme Court where there's some really interesting business decisions. We know we have a large business audience for this show, and we're going to be bringing another show with Joe to talk about business decisions out of the Supreme Court.
It's all coming up on a future edition of The Verdict, and we'll see you then.
The preceding program was produced exclusively for the Cox Channel.